From the Library of Congress in Washington, D.C.
Hello, everyone! This is so great! I'd never been to the National Book Festival before. This is amazing! Look how many people are here. We're like pathetic writers. We sit in rooms by ourselves and we complain. And look at this. This is unbelievable. Now, I was supposed to be introduced by my friend Chuck Lane, who is AWOL, but I will tell you that Jeffrey Toobin is one of the most distinguished and handsome. No, anyway. Hello, everyone. This is great. I am really so flattered to see such a great crowd. It's a wonderful celebration of books. So I know we're going to go to questions later, but I think I'd maybe anticipate a question that I might get later. That question is, who's your favorite justice? Okay. See, this is a hard question for me because I need a new one. Because my favorite justice for so long was David Souter, and he left a couple years ago. Big rousing applause from 3 people all right, no. David Souter. No, David Souter was so great, just as a character. Here's a guy, he didn't have a computer. He didn't have a cell phone. He didn't have an answering machine on his phone. He was late for Rehnquist's funeral because they just couldn't find the guy. The phone kept ringing and ringing. He doesn't like electric light. He's honest. He moves his chair around his chambers over the course of the day to catch the sunlight. But no one has a better perspective or had a better perspective on what it's like to be a Supreme Court justice. And I'll tell you one quick David Souter story. So here's a guy. One of the weird things about Supreme Court justices is they are at once really big public figures, but not really that well known to the public. So. For reasons that remain mysterious, David Souter and Stephen Breyer are frequently mistaken for each other. Now, if you know what they look like, they don't really look anything alike, but it happens to both of them all the time. So one time, not too long ago, David Souter, as he often did, was driving from here in Washington to his home in New Hampshire, and he stopped in a little restaurant to get something to eat. And a couple came up to him, and the guy said, "I know you. You're on the Supreme Court, right?" He said, "Yes." He says, You're Stephen Breyer, right? And Souter didn't want to embarrass the fellow in front of his wife, so he said, "Yes, I'm Stephen Breyer." And they chatted for a little while, but then there was a question that Souter wasn't ready for. The guy said, "So, Justice Breyer, what's the best thing about being on the Supreme Court?" He thought for a minute and he said, "I'd have to say it's the privilege of serving with David Souter." How can you not love that guy, But he's gone now. Okay, so let's do a little Supreme Court by the numbers. 6 men and 3 women. First time in history there are 3 women on the Supreme Court. It's not Canada. Canada has a majority of women. 6 Catholics and 3 Jews. First time in history, no Protestants on the Supreme Court. Now, I don't think there should be applause for that. I would just like to say, we love our Protestant friends. There are 6 products of Harvard Law School and 3 products of Yale Law School, which is absurd and ridiculous that there are actually other law schools in the United States. There are representatives of 4 New York City boroughs on the Supreme Court. Sonia Sotomayor is from the Bronx, Antonin Scalia is from Queens, Ruth Ginsburg is from Brooklyn, and Elena Kagan is from Manhattan. Tragically, Staten Island is unrepresented on the Supreme Court. But, we can always hope for the future. Those are, I hope, interesting facts about the Supreme Court, but I don't think they are terribly important facts about the Supreme Court. Here's an important fact about the Supreme Court. There are 5 Republicans and 4 Democrats. Now, I will speak for a little while longer, but now you know most of what you need to know about the contemporary Supreme Court, that this is a court just over there across First Street from the Capitol. It resembles the Capitol more than the justices would like you to believe. It is another place where Democrats and Republicans fight. And to see the significance of this particular moment in Supreme Court history, I think you need to go back a little bit in time, because the court is very evenly divided, and it's been evenly divided for a long time. But there was a time in the mid and late 1960s when it was not evenly divided. There were 7 liberals on the Supreme Court towards the middle and end of Earl Warren's tenure at the Supreme Court. There were a liberal agenda at the Supreme Court. You had, year after year, case after case, which, moved the court and the country emphatically in a more liberal direction. 1964, New York Times against Sullivan, revolutionizing libel law and giving the press important new protections. 1965, Justice Douglas's famous opinion in Griswold versus Connecticut, the case that said the states could no longer ban married couples from buying birth control. It established the right to privacy and really set the stage for the abortion cases to come. 1966, Chief Justice Warren's opinion in Miranda versus Arizona, revolutionizing criminal procedure and perhaps more importantly, changing television dramas forever. Right? Because everybody knows the Miranda warnings, right? 1967, perhaps the best named case in Supreme Court history. What was the case in 1967? Loving versus Virginia. Loving versus Virginia, the case that said that states could no longer ban racial intermarriage. It is worth pausing for a moment to think that it was only in 1967 that the Supreme Court got around to that ruling. There are people in this room who were alive in 1967. Am I right? Yet, when Barack Obama's parents got married in Hawaii in 1960, there were people in prison in this country for the crime of doing what they did, having a racial intermarriage. And it is just worth pausing to think how different a country this is and it was, and worth celebrating, I think, that idea seems so utterly obscene and preposterous. But you never know how stuff is going to work out in terms of Supreme Court vacancies. Jimmy Carter is the only president in American history to serve a full term and not have the opportunity to name anyone to the Supreme Court. And Richard Nixon got 4 vacancies in quick succession. You'll recall that Richard Nixon was only president for 5.5 years. He had to leave early, which I'm sure you remember if you were alive then. But 4 justices left in those 5.5 years. Chief Justice Warren, Abe Fortas, John Harlan, and Hugo Black. They all left while Nixon was president, and Nixon named all their replacements. Well, who did he name? He named Warren Burger, Lewis Powell, Harry Blackmun, and William Rehnquist. And as you think about that list, I think it illustrates something about the Supreme Court, but something more important than even that. It illustrates the most important political development of our lifetime, which is the evolution of the Republican Party. The Republican Party of the 1970s is unrecognizable from the Republican Party of today, and you saw that in Richard Nixon's Supreme Court appointments. A lot of people thought, once Nixon got all those appointments, that the court was going to get much more conservative. But it didn't. And in fact, the 70s were nearly as liberal as the 60s at the Supreme Court. Think about the big cases of the 70s. They endorsed school busing. They ended the death penalty in the United States in 1972. They let it back in 1976. They essentially threw Nixon out of office in the Nixon tapes case. And still, the most controversial case of them all, 1973, Roe versus Wade, the case that said states couldn't ban abortion, that was a 7-2 opinion. The only dissenters were Byron White, appointed by President Kennedy, and William Rehnquist. 3 of the 4 Nixon justices were in the majority in Roe v. Wade. Inconceivable today for Republican appointees. But times began to change particularly in 1980 with the election of Ronald Reagan, because Ronald Reagan brought with him to Washington someone who I think is a very underrated figure in recent American history, Edwin Meese. Edwin Meese was a White House advisor, later Attorney General. We will not hear any hissing in this audience. And Ed Meese said, look, there's been a liberal agenda in the Supreme Court. We need a conservative agenda. And 1981, when President Reagan was inaugurated, it was also the year the Federalist Society was founded. You know, a lot of liberals talk about the Federalist Society as if it's something out of the Da Vinci Code, that it's some like... No, it's just an organization of conservative lawyers, but it's no coincidence when it was started. What was that conservative agenda? Expand executive power, end racial preferences intended to assist African Americans, welcome religion into the public sphere, and above all, reverse Roe versus Wade and allow states, once again, to ban abortions. A big part of the Reagan Revolution was the arrival in Washington of a group of brilliant young conservative lawyers who wanted to be a part of it. Who were two of the best and the brightest of that group? John Roberts and Samuel Alito. No coincidence then that they are where they are now. Some of the documents that came out during that period when they were nominated to the Supreme Court, very interesting. 1985, Samuel Alito in a memo plotting litigation strategy in the Solicitor General's office. What can be made of this opportunity to advance the goal of bringing about the eventual overruling of Roe v. Wade? Later that year, applying for a promotion, he wrote, I am particularly proud of my contributions to recent cases in which the government has argued in the Supreme Court that the Constitution does not protect the right to an abortion. Samuel Alito then, Samuel Alito now. But the party of Ronald Reagan was not the party of, I was going to say Mitt Romney, but I mean like the current Mitt Romney, not like the last Mitt Romney. And Reagan did not, was not as conservative as many of the people in his own administration. He made a promise in the campaign of 1980 that Jimmy Carter didn't even make. He said, if I have the chance, I will appoint the first woman to the Supreme Court. Potter Stewart unexpectedly announced his resignation right after Reagan became president. Reagan said to his people, look, I'm going to keep this promise, find me a qualified woman. Not a simple task in those days because the pipeline of Supreme Court appointees, circuit courts and whatnot, didn't have a lot of women and had even fewer Republican women. So Reagan's people had to go all the way to the Intermediate Appeals Court in Arizona, not even the Arizona Supreme Court, to find the extraordinary figure who was and is Sandra Day O'Connor. But Justice O'Connor was not. Hissing is not allowed. Applause for Justice O'Connor is allowed. So, but O'Connor was not some sort of super social conservative. Even then, not a religiously oriented conservative. But that was just fine with President Reagan. And that was the kind of justice she turned out to be. 1986, Chief Justice Warren Burger stepped down. Reagan elevated Rehnquist from Associate Justice to Chief Justice, named Antonin Scalia to that seat. No question, conservative justice. The following year, 1987, a critical moment in the history of the Supreme Court, in the history of our country, because Lewis Powell stepped down. And Lewis Powell was the swing vote of his day, so that seat was very important. And Ronald Reagan nominated Robert Bork. Robert Bork. And something very important had happened between the confirmations of Scalia and Rehnquist in '86 and the nomination of Bork in '87. The Democrats had retaken control of the United States Senate. So the chairman of the Judiciary Committee was no longer Strom Thurmond of South Carolina, but instead a young senator from Delaware named Joseph Biden. And Joseph Biden orchestrated a set of hearings where Robert Bork, brilliant, outspoken, ethical, honest, prolific, and very conservative, talked about his views on the issues, and the Senate said, too conservative. And he lost 58-42, and President Reagan nominated Anthony Kennedy instead, who has been a conservative justice by and large, but not nearly as conservative as Bork would have been. That really set the stage for the Rehnquist Court, which I wrote about in my last book, not the current book, The Nine. And, you know, when I started to write The Nine, I was inspired by a book that I'm sure is familiar to many of you, called The Brethren, by Bob Woodward and Scott Armstrong, you know, one of the definitive works of recent years. And, you know, the theme of that book was how all the justices really couldn't stand Warren Burger. They thought he was a pompous jerk, and they didn't get along, and there was lots of infighting. And, you know, if you look at the history of the Supreme Court, that's really the rule more than the exception. I don't know how many of you have had the misfortune to hear of a justice named James McReynolds, who served on the court from 1914 to 1941, who was such an appalling anti-Semite that he used to get up and leave the conference room whenever Justice Cardozo or Justice Brandeis would speak. William O. Douglas, a cantankerous liberal, served on the court for 36 years, longer than anyone else. He had a terrible car accident in the 1950s. He drove his car off a cliff. And the first question everybody asked back at the Supreme Court was, where was Felix Frankfurter at the time? Because they hated each other so much. They thought that... And you know, that's what I expected to find when I started looking behind the scenes at the Supreme Court. Well, to my disappointment as a journalist, but somewhat to my satisfaction as a citizen, I learned that Rehnquist was not. The Rehnquist court was not that kind of place. William Rehnquist was popular among his colleagues. Why? In part, he was popular because he engineered a tremendous reduction in the court's workload. Seriously, in the 80s, the court was deciding about 150 cases a year. By the time Rehnquist died, they were deciding about 80 cases a year. Do the math. 80 cases divided by 9 justices, divided by 4 law clerks apiece. No wonder they live so long, right? I mean, it's a pretty cushy deal being on the Supreme Court. You know, in the 80s, there was a proposal the workload was so great that there was a proposal to add sort of a whole new layer of appeals courts to help the Supreme Court out. And Warren Burger actually liked this idea, and it went to the it went to the White House counsel for his opinion. And the White House counsel at the time assigned a young lawyer on his staff named John Roberts to evaluate it. And this is what John Roberts wrote in a memo. While some of the tales of woe emanating from the court are enough to bring tears to the eyes, it is true that only Supreme Court justices and school children are expected to and do take the entire summer off. The chief doesn't talk this way anymore. The summers off look particularly good now from where he's sitting. And it is true, under Chief Justice Roberts, the court remains a congenial place. It is not a place where people really don't like each other a lot. And to do that, to see that, you need only see the Supreme Court in action. I'm sure in a group like this, we're only steps away. I hope you all have had the opportunity to see a Supreme Court oral argument. It's really, I cannot recommend it highly enough. It's a great thing to do. Bring your friends from out of town. Go to the Supreme Court website. They'll explain how to do it. It's really easy. And there is, of course, one very well-known fact about Supreme Court oral arguments, and that is there are 8 justices who are very engaged and very well prepared and ask lots of hard questions, and Clarence Thomas does not ask any questions. February 22nd, 2006, the last time Justice Thomas asked a question. 6.5 years ago. And you know, those of us who go to the arguments all the time, you know, we sit there, we're very close to the justices, and we always think, will this be the day? Will this be it today? Maybe it's today. And it never is. It just never is. But this is the important thing. Justice Thomas is not an isolated or unpopular figure among his colleagues. He is very popular among his colleagues, and he is a highly influential justice among his colleagues. Someone who has brought conservative ideas to the court that have repeatedly been enacted into law, whether it is the view of the Second Amendment that gives individuals a right, whether it is the ideas behind Citizens United, whether it is 4 but not quite 5 votes on the Commerce Clause in the healthcare case. I mean, Thomas, and if you see him in oral argument, he passes. You know, he and Breyer, they tell jokes, they laugh. I mean, Breyer, just for his own bizarre reasons, he chooses never to ask questions. Thinking about the Rehnquist Court, it is useful, I think, to divide it into 2 parts, 1986 to 2000 and 2000 to 2005. And the dividing point in the history of the court, and in many respects a dividing point in the history of our country, is the court's decision in Bush v. Gore. Now, Justice Scalia, as I'm sure many of you know, does a lot of public speaking, takes questions from the audience, and he often gets a kind of nasty, confrontational question. Yeah, but what about Bush v. Gore? And he always says the same thing. He always says, oh, get over it. Well, speaking just for myself, I am not over it 12 years later. the last book I wrote before the 9 was a book called Too Close to Call about the recount in Florida. And one of the things I wanted to do in that book was interview Al Gore, right? I mean, if you're going to write a book about that, you'd certainly want to get his perspective. Well, I tried everything. I wrote, I called, I worked every connection I had, and Gore wouldn't talk to me. Well, so I wrote the book without him. Just by coincidence, while I was working on the 9, I met Al Gore at a social occasion, and he had read Too Close to Call, and we were talking, and I said, you know, Mr. Vice President, you're not going to believe this, but I'm writing another book where Bush v. Gore is at the center of it. I said, I think I must be the biggest Bush v. Gore junkie in the world. And he said to me, you may be second. And I think you'd have to agree that he has the nod there. But the court had a curious reaction to Bush v. Gore, because as I believe you know, Bush won that case, and he became president. And from 2000 to 2005, the court moved to the left. The court got more liberal. Think about it. That's when they ended the death penalty for the mentally retarded, ended the death penalty for juvenile offenders, decided Lawrence v. Texas, the case that said gay people could no longer be thrown in prison for having consensual sex. They saved affirmative action in the University of Michigan Law School case, Justice O'Connor's famous decision. And in case after case, they rejected the Bush administration's position on the treatment of the detainees in Guantanamo Bay. Why? What happened? Why did the court move to the left? Well, remember the theme I talked about earlier, the evolution of the Republican Party. Sandra Day O'Connor grew more and more alienated from the modern Republican Party. She was the swing vote. She didn't like John Ashcroft. She didn't like the way the war on terror was being conducted. She didn't like the war in Iraq. And above all, Justice O'Connor was alienated by an event that doesn't get talked about a lot these days, but I think is actually a highly significant event from the last decade, and that's the Terri Schiavo case. The Terri Schiavo case had a big impact on Justice O'Connor, in part because it dealt with the issue of judicial independence, which she cared a lot about, but also the issue of who cares for a critically ill family member. And it was at precisely that time that her beloved husband John was descending into the grip of Alzheimer's disease. And she ultimately left the court to take care of her husband. And as I describe in my new book, The Oath, there was a moment when just about the end of O'Connor's term, and she's having a conversation with David Souter, and she says, why is my party destroying the country? We used to be the party of balanced budgets. We used to be the party that was against foreign adventures, and Barry Goldwater never gave a damn who you slept with. But that was a vanishing Republican Party. Think about the last 3 vacancies on the Supreme Court. Who were the last 3 people to leave? O'Connor, David Souter, and Stephen Breyer. I'm sorry, no, Stephen Breyer's still there. I take it back. Sorry, Justice Breyer. Justice O'Connor, Souter, and John Paul Stevens. 3 more different people you will never meet. Sandra Day O'Connor, this tall, charismatic, outgoing politician from Arizona. David Souter, the shy, reclusive bachelor from New Hampshire. John Stevens, this wily antitrust lawyer from Chicago. What do they have in common? They are all moderate Republicans who left the Supreme Court completely alienated from the modern Republican Party. And the 2 of them, or Rehnquist and O'Connor, were replaced by modern Republicans. And the moderate Republicans who controlled the Supreme Court for more than a generation, whether it was Potter Stewart in the 60s or Lewis Powell in the 70s or Sandra Day O'Connor later, they are gone. They're gone from the Supreme Court, just like they're gone from the Senate and they're gone from the House of Representatives. And now we have the more conservative party. And we see that in case after case before the Supreme Court. We see it in the gun control case about the Second Amendment. We see it in Citizens United, which is the signature case of the Roberts Court, which is a case that has had transcendent impact on politics. And Stephen Breyer, who is hardly a hysteric, said not too long ago about the new justices, "It is not often in law that so few have quickly undone so much." But I hear you ask, Yeah, but what about health care? How does that fit into all this? Because as you know, John Roberts did not vote with his conservative colleagues in the healthcare case, even though there were some television pundits who predicted that the result was going to be otherwise. But we all know better than to listen to them. See, this is the problem with TV, is like they keep tapes of what you say. No, I was very wrong in my prediction about how the healthcare case would go. But I now stick to predicting the past rather than the future. And I can explain it all very well. So why? Why did Chief Justice Roberts side with, take the other side? Well, I think, there is you got to take what he said at face value. He was persuaded that the argument was that the law was constitutional under the taxing power of the Congress, and even though he said it wasn't constitutional under the Commerce Clause, which was most of what the justices discussed during the oral argument of the case. But I don't think that's the whole story. I think Chief Justice Roberts, in addition to being very conservative, is someone who cares deeply about the institutional reputation of the Supreme Court. And he saw what so many people saw, that this was a court that was becoming another place where Democrats and Republicans fought. And the healthcare case was, to many people, including some of the justices, simply the third in a trilogy. Bush v. Gore, 2000, Citizens United, 2010, the Affordable Care Act in 2012. And in both of those first two cases, you had the 5 Republican conservatives dashing the hopes of the Democrats. And here it looked like, and it certainly looked to me, after the oral argument, that it was going to be the 5 Republicans dashing the hopes and depriving the Democrats of the signature legislative achievement of 2 or 3 generations. So Roberts saw a way out of that partisan trespass. And the last reason I think Chief Justice Roberts did not rule with his conservative colleagues is that the judicial philosophy reflected in the argument against health care, that the Commerce Clause did not allow, and that the taxing power did not allow this sort of federal legislation, was not and is not part of the traditional conservative agenda at the Supreme Court. The idea of an individual mandate has been around for decades, mostly from conservative sources, and no one suggested that this law was unconstitutional until about 6 months before the vote in Congress, and Barack Obama proposed it. This was such a transparently political argument that Roberts pulled the court back from the abyss. But I assure you of this: John Roberts has not suddenly discovered his inner moderate. This is a very conservative Chief Justice, a very conservative court. We are looking ahead to a term where they will look at the future of affirmative action in higher education. In the University of Texas case, I think likely to overturn Justice O'Connor's opinion in Grutter. They are looking at the future of Section 5 of the Voting Rights case, perhaps the most important civil rights law ever passed. They are looking at the Defense of Marriage Act, perhaps Proposition 8. John Roberts was and is very conservative. But one thing no one will ever be able to accuse John Roberts of after last June 28th, he is no partisan hack. He wasn't then, he isn't now, but he is a leader for this court for at least the next generation. And with that, I look forward to taking your questions. Thank you. You know, point the microphone more at your mouth so everybody can get a little closer.
Well, thanks for bringing the Supreme Court alive.
Closer.
Thanks for bringing the Supreme Court alive to a lot of us. I
You're
appreciate
welcome.
it. I haven't had a chance to read the whole The Oath, the new book.
The Oath?
I haven't had a chance.
You know what? For sale, right over there.
I'll talk to you in a second.
Just
But
parenthetically.
since you won't, I will call Roberts a conservative hack. But what about Powell? What about the fact that the U.S. Chamber of Commerce had this whole plan for a long time? You know, Buckley Vallejo, obviously Citizens United. I think the definition of conservative in some ways has changed.
Oh, dramatically. Well, I mean, just the reference to Justice Powell. Justice Powell, before Richard Nixon appointed him to the Supreme Court, was a very prominent lawyer in Richmond, Virginia, and he wrote a memo that said, before he was on the Supreme Court, look, there are all these liberal think tanks, there are all these liberal universities. We need to start funneling money into conservative foundations and nonprofits that put forth conservative ideas. And that was, in many respects, the birth of the Heritage Foundation, the American Enterprise Institute, Cato Institute, and they have been enormously influential. They have been influential in part because they are wealthy, but in part because they recognize the power of ideas. And the powers of the idea of originalism, which is associated with Justice Scalia and Justice Thomas, the idea that the Constitution should be interpreted as the framers understood it. That is a very controversial idea, but one that is widely adopted because conservatives pushed it so much. Yes, to be sure, money has a lot to do with it, but that's not the only thing. And I think conservatives deserve a lot of credit for taking ideas so seriously. Yes.
Just on? There
Yes.
we go. So last year, Justice Thomas had to amend years and years of financial disclosure forms after he omitted his wife's employment by the Heritage Foundation, by Tea Party groups, which raised a whole question about Supreme Court ethics and the fact that the Supreme Court is not bound by the same judicial code of ethics that courts of appeals are. Do you have any comment on Supreme Court ethics and whether there might be some sort of a movement for some standards?
I would just to expand on what you said, the Supreme Court is unique among federal courts in that it really operates on the honor system. There are no formal rules for recusal, and there was some controversy about Justice Thomas' participation in the healthcare case because his wife, Virginia Thomas, was so outspoken against it. I think Justice Thomas's participation in that case was just fine. They are a two-career family. Virginia Thomas has been a political activist for decades. This is her job. She is not required to quit her job because her husband is a Supreme Court justice. There was no financial conflict of interest. Justice Thomas didn't stand to make money because health care was upheld or overturned. Look, let's not kid ourselves on why the bunch of congressmen wrote a letter saying Thomas should recuse himself. Look, they knew how Thomas was going to vote. That's why they wanted him off the case. This was one of the things I don't like about Washington, with all respect to your community, is that substantive debates are transferred into ethical debates. And, there's no ethics issue here. There is an issue of substantive disagreement, and that's what we should be fighting about, not phony ethics conjuring. Now, the good news for Justice Thomas was the leader of the fight to get him to recuse himself was Congressman Anthony Weiner, who was later distracted by other matters. And anyway, yes. Tilt it down so people hear you.
Yeah.
Come a little closer. There you go.
Okay.
Good.
I'm a student at George Mason, and we had a class on politics and mass media, and we talked about how C-SPAN has kind of changed the way that we look at the Capitol and the way that Congress members and Senate members are able to, they're taped, so there is a record of it. I was wondering what your opinion was on having the Supreme Court being taped too, or on C-SPAN. We talked about the negatives and positives of that occurring.
Cameras in the courtroom.
Yeah,
well, as far as I'm concerned, it is preposterous and absurd that the Supreme Court is not televised. I mean, there are at least plausible arguments against cameras in trial courts with jurors and witnesses. There are no witnesses in the Supreme Court. And everybody's there is a grown-up. But you know what? It's their candy store. And in fairness to the justices, they are all very protective of the institution. I mean, I was surprised, and I was only slightly appalled. Elena Kagan, when she was nominated in her congressional hearings, she said, well, I think cameras in the courtroom are a good idea. She hasn't even been there in a year and a half. And it's like, oh, no, I don't know. I don't think so. And it's like, oh, come on. They now, all the audio tapes of the Supreme Court are released at the end of the week now of when they have oral arguments. I think in 5 years, they will probably stream the audio on the web live. That would be, in their eyes, a kind of compromise. It wouldn't affect them at all. It wouldn't, affect the architecture. But I just think they're very worried about Jon Stewart. I mean, they are worried. I'm serious. They don't want to be made fun of. And you know, neither does Mitt Romney, neither does Barack Obama. But you know what? When you're in public life, deal with it. That's part of your job. So I think it's a preposterous objection on their part, but I'm not holding my breath for any change. Yes.
Thanks again, Mr. Toobin. Could you look at the crisis on the circuits, retirements, held nominations in the Senate? That's one question. The other one is, I'm going to try again to get you to say something. Anthony Kennedy in November 2000.
Okay. You know, one of the stories I tell in the oath is about Barack Obama and the courts. And one of the paradoxes of the Obama presidency is here is a liberal democratic president who is a former constitutional law professor who does not have that much interest in the courts. One of the defining differences between the contemporary Democratic and Republican parties is that the Republicans care about the courts a lot more. And President Bush, even the first President Bush, put a lot of emphasis on getting young conservatives on the court. They spoke out against the Senate when their confirmations were delayed. There has been unprecedented obstruction of President Obama's judicial nominees. But there has also been unprecedented lack of interest in putting forth judicial nominees in the Obama White House. They have not filled all the vacancies. President Obama has never given a speech on this issue, and it is an amazing missed opportunity in the Obama presidency. Perhaps different in a second term if there is one. Yes. I'm sorry, I just don't have anything to say about Anthony Kennedy in November 2000.
Loved your book, The Nine. Really enjoyed it.
Thank you.
I would like to know what the impact is of the different law clerks on the, you might say, the decisions of their Supreme Court justices.
Well, one of the things I have done is in reporting both The Nine and the Oath is I've spoken to a lot of law clerks. And you know who thinks law clerks are really, really important? Law clerks. And you know, who can blame them? You know, it's their 1 year of, you know, proximity to greatness and proximity to importance. I think it is their influence is vastly overstated. They do a lot of drafting, just like in big law firms. You know, the junior people do the drafting, but they don't decide the cases. They fight with each other in footnotes, but I just don't think they are all that significant. The justices call the shots. Yes, I'll be faster.
Yeah, big fan of your books.
Thank you.
As a journalist, a question: how do you go behind the scenes here? The sources, the scenes, the portraits. It seems like such an opaque institution. How do you even begin reporting on the court?
Well, you start with a thick skin because a lot of people tell you no. A lot of people say, it's private, I'm not talking about it. But the combination, I'd like to say, of doggedness and just keep asking, and also having a reputation for fairness and thoroughness and accuracy. I think it's a great privilege to work at the New Yorker magazine. I think when you call and say you're from the New Yorker, people think that your story at least will be factually accurate. And I just think it's just a process of asking a lot and not being disappointed when people say no. Yes?
Since you mentioned Jon Stewart, could you give the secret for surviving interview by Jon Stewart and Stephen Colbert?
Well, being on Jon Stewart and Stewart Colbert, you know, Stephen Colbert, here is a trivia question that you probably know the answer to. Don't know the answer. Who was the first guest on the Colbert Report ever? Answer: me. And you think it's weird being on now
ever since.
when he walks across and, you know, he gets the applause instead of the guest. I mean, all that started in the first show. The one piece of advice that they give you at the Colbert Report, which you really have to follow, is don't try to be funny. Is like, be the straight man. And Stephen, what he says to you, he always talks about the character. You know, the difference between the two shows is Jon Stewart is Jon Stewart. Stephen Colbert plays a character called Stephen Colbert. And he always says, remember, The character is the dumbest person in the world. You have to explain things to him. So that's the secret. Anyway, yes, we have a very...
Hi, yes. I'm a young GW Law School grad, and I got to sit in on the oral args for the Affordable Care Act case.
Oh, you must have slept there.
I thought it was fantastic.
Oh, yeah, it
I'm
was
the kind
great.
of dork
Yeah.
who loved that. So anyway, my question is in regards to that decision. Does it surprise you, knowing what the breakdown was, two-part question, that Kennedy didn't then join in the majority to help further the integrity of the court so that it could be a 6-3 split?
You know, no, not really. You know, I just think the justices are very independent operators, and you know they are very conscientious and heartfelt in their work. I mean, they don't change their votes willy-nilly. Just to, you know, Kennedy is very conservative in most areas, just not every area. So I wasn't surprised that he didn't switch his vote. He believes that.
And the other part of my
Oh,
question was, do you believe that Roberts changed his decision partway through the decision-making process?
Well, if I could refer you to the oath, which is for sale over here, there's a story there, and it's told rather entertainingly there.
Okay.
Yes, couple more, real fast.
Hi, I have a question about the upcoming term.
Come a little closer.
I have a question about the upcoming term. If you think that the justices will grant certiorari to the DOMA case or the Prop 8, and whether or not, how you think, I know you said your predictive powers are waning these days,
yes.
but if you feel like they'll rule narrowly.
This is a huge issue. I mean, just as my father used to say, to make a long story unbearable. The Defense of Marriage Act is a case that says states which have same-sex marriage cannot, the federal government cannot honor those marriages. So the case out of Massachusetts, the IRS, did not treat two women who were married as married, so they had to pay extra taxes. That case is actually a fairly narrow case because it only applies in states that already have same-sex marriage. I mean, it doesn't tell those other states. Now, the Proposition 8 case, at least viewed from one perspective, is a case that says, does the Equal Protection Clause of the 14th Amendment guarantee gay people the right to get married anywhere, anytime? If they rule that the answer is yes, that means that clerks in counties in Alabama and Mississippi and Texas will have to start granting marriage licenses to gay people starting the next day. I am not sure the Supreme Court, even if 5 justices think that's the right result, are ready to take the heat for doing that just now.
Wasn't the Ninth Circuit ruling narrow enough, though?
Well, I think, in short answer, they could deny cert in that case. Same-sex marriage would then become legal in California. Then approximately a quarter of the country would live in states where same-sex marriage was legal. And state by state, it's on the ballot in Washington State, it's on the ballot in Minnesota, ballot in Maine, Maryland. The court would be, that is a slower process that the court would be comfortable with. I am informed that it is overtime. Thank you so much for coming. So wonderful.
This has been a presentation of the Library of Congress. Visit us at loc.gov.